We'll start with SIGFREDO IRIZARRY. I hope I pronounced his name correctly.
IRIZARRY.
I'm sorry. Go ahead.
May it please the Court.
You want to reserve any time, sir?
Perhaps a minute or so. I don't know that I'll need any, but I don't think I'll use all my time anyway. May it please the Court. My name is Michael Becker. I'm Assistant Public Defender here in Daytona Beach, and I represent the appellant in this case. Mr. IRIZARRY pled to various criminal offenses, and at sentencing was sentenced to a cumulative sentence of 53 years, all being mandatory minimum sentences. This was done over objection by the defense that consecutive mandatory minimums were not required. The trial judge, however, accepted the state's argument that under State v. Souza, a Florida Supreme Court case from 2005, that the trial court was required to impose consecutive mandatory minimum under the 1020 life statute. The issue on appeal, of course, is one of statutory interpretation, so this court's standard of review is de novo. The very narrow question is, are mandatory minimums provided under the 1020 life statute required to be imposed consecutively, or does the trial judge still retain his discretion to impose them concurrently? The case that deals with this is State v. Souza, Florida Supreme Court case, where they trace the whole history of the application of mandatory minimums and whether they can be consecutive or concurrent. They go back all the way to the first case of Palmer, which was a 3-year minimum mandatory for sentencing, and they traced it right up to the present, which included their cases of State v. Christian and State v. Thomas. Nothing in State v. Souza ever holds that a trial court is required to impose mandatory minimums. The court never holds that. The court never holds that the statute requires the imposition of mandatory minimums. Rather, what the court holds is nothing in the statute precludes the trial court from imposing mandatory minimums. That's quite different from saying the trial court is required to impose them. I suggest to you that had the Supreme Court felt that the statute required it, they would have said that. They would have taken all discretion away from the trial judge and said the trial court's hands were tied here, he had to do it. They didn't do that, though, and I think that's very instructive. Further support for the idea that the statute does not require it is the legislative history, which is quoted in the Souza opinion by way of the lower court's opinion. And while they said in this particular case the legislative history shouldn't have been consulted because for other offenses didn't need any kind of interpretation, it was plain, the last line of the legislative history that's quoted there is saying, this provision does not explicitly prohibit a judge from imposing minimum mandatory sentences concurrent with each other. I don't know how it could be any more explicit that the trial court still does retain jurisdiction. And in fact, the Florida Supreme Court, in overruling the district court in Souza, said to accept the district court's interpretation of the statute as amended would require them to say that the legislation overruled their decisions, their prior decisions in State v. Christian and State v. Thomas. They did not. They said this statute, this amendment is consistent with our prior decisions. And those decisions clearly held that the mandatory minimums were permitted but were not mandated. So in State v. Christian, the court specifically held that imposing consecutive mandatory minimum terms, and I'm quoting exactly here, thus is permissible where the defendant shoots at multiple victims and impermissible where the defendant does not fire the weapon. We have no firing of the weapon in this case.
Well, if it's impermissible in that circumstance, why does the trial court have discretion in this case?
Well, I don't think he does. I think he doesn't have discretion.
Well, you started your oral argument by saying that that was a discretionary matter with the trial court.
Well, the trial court ruled that this section gives him no discretion. I think this section gives him discretion if the facts are there for it.
But he's saying under no circumstances can he ever impose concurrent. Well, not only can he impose concurrent, sometimes he's required to.
Is it your argument that in this case he's required to?
That's the way I'm understanding from, because they reaffirmed State versus Christian in Sousa, and State versus Christian couldn't be any more explicit than what it said there, what I just quoted to this court. I think he has to impose concurrent mandatory minimums. If that is incorrect, at the very least, he does retain discretion. I think that's abundantly clear, both from Sousa and from the legislative history of the statute. Is there no other question?
Refresh my recollection. Is the record clear that Judge Eaton in this case felt he had discretion or felt he had no discretion?
I believe it's absolutely clear that he felt he had no discretion. I think I even quoted it in my, I don't know, I didn't set forth the actual quote.
I think you're right.
He clearly said that he, accepting the Sousa case, and that he felt he was required under that to impose the mandatory minimum. Is there any other questions? Thank you.
May it please the Court, my name is Pam Kohler. I represent the state of Florida in this appeal. I think you need to look back a little bit. All these cases that were discussed in Sousa were ruled on prior to the amendment by the legislature. Mondesor is the case that started all this. Mondesor basically said the state cross-appealed in Mondesor. Mondesor, the state said you have to impose, the defendant had a VOP as well as new charges. The state argued, number one, the trial court had to impose consecutive sentences as to the new charges and the violation of probation, and the trial court had to impose consecutive minimum mandatories. On appeal, the appellate court said the state's right that you have to impose the VOP and the new sentences consecutively, and they sent it back without even going to the trial court for any discretion and said you will impose these sentences consecutively. But they disagreed with the state of Florida as to consecutive minimum mandatories because they found that the language of the statute, which talks about any other felony, to mean a separate prosecution, not the same prosecution or same criminal episode. The Sousa court relied upon Mondesor in finding that you could not impose consecutive minimum mandatories. This went to the Florida Supreme Court. The Florida Supreme Court disagreed with the any other felony interpretation and said that no, the statute is unambiguous, you don't have to look at the committee notes, and that if you look at the statute, the minimum mandatories can be stacked.
Where does it say the minimum mandatories can be stacked?
Well, I think that's the only thing that Sousa basically held, is that you could not stack the minimum mandatories relying upon Mondesor. Mondesor said you can stack, or you can run consecutively any new charges and these old charges, but you not the consecutive minimum mandatories. That's all that's basically left in Mondesor. Sousa, the district court in Sousa relied upon Mondesor, basically said we cite to Mondesor, and when it came up in the Florida Supreme Court, they basically said that we disapprove Mondesor to the extent that is inconsistent with their opinion in Sousa.
Let me just ask, in Sousa, the court specifically reaffirmed its holding in Christian and finds that the statute that you're discussing today is consistent rather than inconsistent. Now, if we were writing on a clean slate, I might not reach that same conclusion, but that's the conclusion they reached. And in the Christian case, the specific holding of that case was that imposing consecutive mandatory minimums is permissible where the defendant shoots at multiple victims and impermissible where the defendant does not fire the weapon. Now, again, we could disagree on whether, if we were on the Supreme Court, that's the holding that we would reach, but that's the holding that they reached. That's the clear holding of Christian, which they clearly reaffirmed. How do you wiggle around that one?
I mean, I don't see how they found that Christian is still good. I understand.
I don't disagree with you. I'm just asking you if you know, how do you wiggle around that one? I mean, I can't find a way to wiggle around that language.
Other than in Christian and in Sousa, you had shootings, and so maybe they, you know, I guess you can't say that the Supreme Court was neglectful or overlooked their prior, I mean, because the law is clear. The law says.
Hey, I take them at their word. I'm just reading you
Right.
what the holding is, which they specifically reaffirm. Impermissible where the defendant doesn't fire the weapon. And we all agree in this case the defendant doesn't fire the weapon.
Right, he racked around, but he did not actually
Right.
shoot.
And so I'm just asking you to give me your best shot, given the fact that, like it or not, you and I are both obliged to follow that holding in Sousa that they adopt again from Christian. What's your best shot on wiggling around it?
The best shot I have is those cases involve shooting, so the issue whether or not minimum mandatories could be stacked for a non-shooting case was really not before the court at the time.
Did you and Mr. Becker try to settle this with arm wrestling? Because I see that he may have a stronger one here. If his right arm or left arm, I guess it is, wasn't helping him. I mean, I'm sympathetic to what you're saying. But when I went back and I read all those cases. I tried to follow them all and figure out what rule. I think if I had been on the Supreme Court, I would have adopted a position that the state advocates here in Sousa, but I'm not on the Supreme Court, and they didn't adopt it, and I can't come up with an intellectually honest way to wiggle around that clear language.
I mean, obviously Christian relies some on Palmer. Palmer is obviously not inconsistent because Palmer just said 775-087 did not authorize it, and this is back in 1983. Obviously, as of 1999, it does authorize stacking minimum mandatories.
Right.
I know, it's because the language of the statute is pretty clear, and it's not consistent with Christian. So, you know, other than the fact that that was a shooting case, and we don't have a shooting case here.
So you would concede that at best you got an uphill struggle here based upon the holding of Sousa.
Only because Sousa seemed to affirm, although Sousa is not a very clear opinion.
But they're the Supreme Court.
Correct, I understand that. And, you know, hopefully you can give me something I could take up there, or, because I would certainly be happy to argue this in front of the Florida Supreme Court. Because it's clearly not the intent of the legislature that if you don't fire a gun, you cannot have your minimum mandatory stacked. It's clearly not the intent of the legislature from, 775-087-2D. And Christian said you could not, and that is not what the legislature intended. Christian was, obviously ruled on and issued prior to 1999, before this new subsection. But obviously Sousa was after the new subsection. Like I said, the only thing I can think of is if I will argue it for the Florida Supreme Court, and I will be happy to take it up there and argue differently. But I certainly understand your position, Your Honor.
We appreciate your candor.
But like I said, other than the fact that we didn't have a shooting in this case, and those cases clearly involved shooting, so they didn't even have to consider whether or not non-shooting under the Christian case could not be stopped. That's basically the state's position.
Not that I've made up my mind or anything.
I understand, but I think that the language of the statute is very clear. And
The problem is, so is the language of the case.
Well, and the Supreme Court also said the statute's unambiguous. And, you don't have to look at the committee notes. And, the language is very clear. We shall impose them consecutively.
Is there any rule that says when the Supreme Court conflicts with the legislature, we've got to choose one or the other?
Yeah, choose the Supreme Court.
Well, in double jeopardy cases, obviously you're to look to the intent of the legislature. They're the ones that get to decide if it's double jeopardy or not. And here they said, and that's basically been the basis for the ruling that you could not stack mandatories if there's some sort of double jeopardy violation. Here the legislature has made a plain statement. We want to punish these people to the full extent of the law, therefore you shall impose these sentences consecutively. And that's based on this ruling by the Florida Supreme Court, that is not what is going to happen in these cases, because someone who gets sentenced in the 1020 life can get a shorter sentence than someone who's sentenced without the 1020 life. They could have their sentences stacked.
You have my sympathy, but very little else. Thank you, counsel.
But anyway, I would be happy to take it to the Supreme Court if this court should so decide. Thank you.
Well, it might be worth,
I would be willing to argue it. I think
that's your
it's
call.
a valid argument that Christian is no longer good law as far as when there's no shooting. You can't stack any mandatories.
Thank you so much.
Thank you.
Counsel, do you have anything to add? You had maybe a minute or two.
Thank you.